President, tomorrow morning at 10 a.m., the Supreme Court of the United States will hear oral arguments on a case out of Mississippi, commonly known now as the Dobbs case. That case is all about a Mississippi law where Mississippi passed a law saying at 15 weeks, a child in development in the womb can be protected after that time period. That strikes right at the heart of Roe v. Wade, where in the arbitrary ruling from the Supreme Court in 1973, they made up a new rule saying when a child is viable, not something that's in law at any spot, created that out of whole cloth. Tomorrow morning, the Supreme Court will reopen that conversation about viability. It's an important discussion for us to be able to have as a nation, and it's vital that we talk about it here as well. As it's being discussed across the street at the Supreme Court, there are also that we should discuss here as well. So for the next few moments, there are multiple different senators are going to speak on this one issue. When is a child, and when should states have the rights to protect their own citizens' lives? The Supreme Court's made that murky and has the option tomorrow to be able to make that clear. This conversation, though, will circle around what should that legal standard be, and how should we protect the lives of every citizen, no matter how small they are. There'll be multiple senators that will be speaking on this one, the first of which will be Senator Steve DAINES, who leads the pro-life caucus in the United States Senate.
President.
Senator from Montana.
Mr. President, I rise today ahead of one of the most important moments in our decades-long battle to protect life. When our founding fathers laid out the Declaration of Independence, they talked about life, they talked about liberty, and the pursuit of happiness. They called them certain unalienable rights endowed by our Creator. The reality is you can't have liberty and the pursuit of happiness without first having that unalienable right given by God, and that is the right to life. Tomorrow, the United States Supreme Court will hear oral arguments on the Mississippi late-term abortion case, Dobbs versus Jackson Women's Health Organization. This puts our nation at the crossroads of history. Our nation has a moment to finally modernize our laws. We've got the opportunity to catch up with the great advances we've seen in science, in technology, and medicine that indisputably shows the humanity of unborn children. We have the opportunity to end an extreme, judicially imposed abortion regime that's aligned with nations such as China and North Korea. The United States is just one of 7 nations that allows late-term abortions. We have the opportunity to write a new chapter of American history where the people's elected representatives get to decide abortion policy in this country. The Supreme Court of the United States has the chance to right a historic injustice and finally overturn Roe versus Wade. Our court's 9 justices have the opportunity to reconsider a wrongly decided case. And by the way, that wrongly decided case that became case law, it was 9 men in black robes that really have overruled the will of the people. It wasn't a state legislature. It wasn't the U.S. House. It wasn't the U.S. Senate. It was 9 men in black robes in 1973 that has since resulted in the death of over 62 million innocent babies. 62 million. They have the opportunity to reverse this horrific decision that imposed abortion on demand until the moment of birth across the United States. They have the opportunity to recognize that Roe was based on flawed and outdated science, and that the right to abortion, which Roe invented, has no support in the text, the history, or the structure of the Constitution. The Supreme Court has an opportunity to restore the Constitution and defend our most fundamental right, and that is a right to life. Now let's go back to 1973 when Roe was decided. Many things were different than they are today. Why? Well, one reason is because science and technology, and certainly fashions, have advanced greatly. Our phones in the 1970s went from large brick-like devices with antennas. In fact, the first cell phone call was placed in 1973, the very year that Roe v. Wade is decided. They were called bricks. They were about 2.5 pounds. Compare that to these thin touchscreen smartphones that we fit in our pockets today that are less than 6 ounces of weight. In the 1970s, computers were the size of an entire desk. And now we have laptops that can be thin as literally a child's story I read to my grandchildren over the Thanksgiving holidays. Now, when we drove in the 70s, compare that to what we drive today. I'm thankful that's changed. And in the 70s, if you were a woman at the doctor getting an ultrasound at the 15 weeks into the pregnancy, you would have seen something like this. That's hard to recognize, but that was a technology that some ultrasounds had the best back in the 70s. But today, an ultrasound of a baby at 15 weeks, when you're using the latest 4D technology, looks like this. You literally can see this little one here at 15 weeks sticking her tongue out. 15 weeks. A baby this size is who Mississippi's historic life-saving law would protect from the brutal violence of a late-term abortion. That is a 15-week baby. And if you don't believe me, take out the smartphone, Google 15-week baby, and click on images. Roe and Casey made it illegal for states like Mississippi to enforce laws that protect babies like this one on the grounds that this baby cannot survive outside the womb. There was a point called viability. Roe and Casey's viability line is arbitrary, it's unscientific, it's morally repugnant. Because in 1973, babies could survive outside the womb at 28 weeks of pregnancy. Today, babies are surviving outside the womb as early as 21 weeks, but not yet as early as 15 weeks. It is barbaric to deny life-saving protections to a helpless preborn child like this one simply because she cannot survive outside the womb. The reality is, even a full-term 40-week-old baby needs nurturing care and medical assistance to survive outside the womb. A full-term baby delivered at 40 or 41 weeks still requires the nurturing and the care of the parent to survive outside the womb. They've got to be fed. They've got to be kept warm. They've got to be taken care of. They can't do it on their own. Martin Luther King once said, "Injustice anywhere is a threat to justice everywhere." This is also true in the case of the Supreme Court's prior unjust decisions on abortion. In fact, the logic of Roe and Casey's viability test undermines the moral coherence of civil rights protections for everyone who is unable to survive without assistance from others. That includes infants, young children, the elderly, and persons with disabilities. A preborn child is not a, quote, potential life, as Roe so wrongly concluded. This precious child and all children inside the womb at any stage of development are whole, they're distinct, they're living human beings. They are fully human and fully living. They are beautifully living children, made in the image of God, who should be protected by the law. Now, we've come a long way since 1973. Our laws must now do the same. As you just saw, at the time that Roe v. Wade was decided, it was very hard to clearly see a baby in the womb. But because of science and technology today, it's impossible to ignore the humanity of this growing baby. If I took this image and we had the American people say, "What is that?" they'd say, "That's a baby." At 15 weeks, a baby has arms and legs, can hiccup, can yawn. The heart's fully developed. At 15 weeks, the heart has already beaten 15 million times. That baby has distinct facial expressions. It can hear the voice of the mother and respond. They can taste, can suck her thumb. As you can see, that other image I had, even stick out her tongue. I'm a father of 4, grandfather of 2. We have another grandchild coming any day. Our daughter's due date, Annie, her due date is December 3rd. It's Friday. And my wife and I, who've been married now 35 years, have our favorite way of tracking our grandbaby's growth. This didn't happen in 1973, but today we have apps on our phones. I've been using an app called Sprout. There's several out there. Downloaded it. I can see how my little grandson is doing in each week of the pregnancy. It's remarkable. Remarkable. We've been following this little baby now since week 8. We're at week 40 here this weekend. This cutting-edge technology is at the tip of our fingers, something that we couldn't even imagine 50 years ago. We'd have that at the tip of our fingers. Our laws must catch up with the advancement of science and technology. It's very important that we're clear about what overturning Roe would mean for our country, because there's a lot of misinformation out there. Let me state this as clearly as I can. Overturning Roe will not, let me say that again, will not ban abortion nationwide, as many on the left like to claim in an attempt to mislead Americans. That is absolutely false. It will not ban abortions nationwide. Instead, it returns the power to the states. It returns the power to federal lawmakers, allowing them to protect the most vulnerable and act on behalf of the people they're elected to represent. Because today under Roe, state lawmakers are robbed of their ability to represent the values of their constituents. Yet because of Roe, the will of the people of Mississippi to protect life is obstructed. According to a recent Marist poll, 80% of Americans are opposed to abortions after the first 3 months, it's 12 weeks, of pregnancy. That is an overwhelming majority of the American people. But because of Roe, their voices are being silenced. It's time for the Supreme Court to allow the states and federal lawmakers, those of us who are elected, who are held directly accountable by the people, to protect the most vulnerable among us. It's time that we, as the United States of America, a nation who is supposed to be a leader in the world on human rights, recognize that innocent babies in the womb deserve equal protection under our laws. I'm sure many of my colleagues and most Americans would agree that nations like communist China and North Korea egregiously violate human rights. Yet, when it comes to abortion, sadly, America stands with them. Just 7 countries, and we're on that list. The United States is a global outlier on abortion. We are just one of 7 nations that allow abortions on demand past the point where a baby feels pain, all the way up, in fact, until the moment of birth. Standing with North Korea and China on abortion is horrifying. It's a disgraceful place for the greatest country in the world to be. We must do better. I want to thank Mississippi Attorney General Lynn Fitch, her entire team, and the Mississippi legislature for their unwavering support of life. We stand with you. Millions of Americans stand with you, young and old. They're praying for this momentous moment that will be occurring before our courts tomorrow. And as we stand here today, we're a mere hours away from a pivotal point in our nation's history. I pray that we'll remember tomorrow as the turning point that closes a really dark chapter of our nation's history and heralds the dawning truly of a new day in America, where those who have no voice finally have a voice, one that honors the human dignity, the God-given potential of all life, one that positions the United States as a leader in the world, that stands up and puts an end to the horrific violence of abortion, especially painful late-term abortions. I pray that we see the Supreme Court of the United States correct a historic injustice, that they would uphold Mississippi's 15-week abortion law and send Roe versus Wade to the ash heap of history. For the pro-life movement, overturning Roe is not the end, but just the beginning. As I stated earlier, this does not ban abortions nationwide. What it does, it will return the decision-making back to the states. No matter how the court rules, we'll continue to fight at the state and federal level to pass laws to end the violence of abortion. We'll not rest until the day that every life is protected under laws from conception until natural death. I want to thank my colleagues for being here today to talk about the importance of the Dobbs case. I want to thank my friend Senator Lankford, who's helping lead this fight for life. I'm grateful to the two senators from Mississippi, where this case originated, this law originated. Grateful for Senator Wicker, who's here today, and I know he has some comments he wants to share as well. I yield back my time.
Mr. President.
Senator from Mississippi.
I congratulate my friend from Montana for his passionate and analytical and, in my view, correct assessment of this issue. I rise this afternoon in support and in encouragement of the public officials and the attorneys who will bring this case before the Supreme Court in argument tomorrow. I rise, as does my colleague from Mississippi, Senator HYDE-SMITH, in appreciation for the state legislature, where she and I both served before coming to Congress, and in appreciation for the governor and the legislature enacting the Gestational Age Act, which is the subject of this Dobbs case, which will be argued tomorrow. This is a serious issue. It's an issue that will determine whether millions of American children have an opportunity to be born and to enjoy the good life in this, the greatest system of representative government that the world has ever seen. So it's a serious issue, but Mr. President, I'm happy today. I'm encouraged and hopeful today, and one of the reasons that I'm so encouraged is that the American people steadily over the decades have been moving in the direction of protecting life. This has not always been the case, and as my friend from Montana so accurately pointed out, we just know so much more. Science knows so much more today in 2021 than science knew and that Americans knew and the world knew back in 1973. And so we see more and more people becoming pro-life. Now, since 1995, the share of Americans who identify themselves as pro-life has jumped to 47% from 33%. Well, you say, well, that's not that great. Of course, it leaves some folks undecided. But when you sort it out and become more specific, 2 out of 3 Americans support a ban on second trimester abortions. This is what the Mississippi law does. This is the law that will be allowed to stay in effect if the Supreme Court rules in favor of Mississippi based on the argument tomorrow. 4 out of 5 Americans oppose late-term abortions. And, you know, my friend, the distinguished senator from Montana, encouraged people within the sound of his voice to take their smartphones out and type in 15-week-old baby, and I did that. I don't know if the rules quite permit that yet, Mr. President, on the floor, but I dare say it's not the first time that has been done. And so I did that. I clicked on 15-year-old baby, and that very picture, along with other photographs, came up. And as the gentleman says, it is every bit a human baby, no question about it. So I'm encouraged that the American people are moving in the direction of life because they've seen these pictures, because they listen to the science, and we know more than we did in 1973. The Supreme Court knows more than it did in 1973. After 15 weeks, an unborn baby has more than 90% of its body parts that it will ever have. They've been formed, and almost every organ is functional at the 15-week period. That's a baby. That's a human American baby. The child's heart is pumping 26 quarts of blood per day at 15 weeks and has already beaten approximately 15.8 million times by 15 weeks. That's a human. That's a baby. Babies at this stage respond to touch and taste, and a dominant hand begins to emerge. We know at that point, 15 weeks, whether that baby is right-handed or left-handed. And of course, we know that that baby can feel pain. That baby deserves the constitutional rights that the gentleman from Montana mentioned of life and the pursuit of happiness as an American. And I do want to congratulate our friends across the sea for actually being ahead of us on this. We like to think that sometimes we know best and we're ahead of the curve. But it happens that almost every European country has legislation in place, rules in place, that are very much like the Mississippi law that will be in question tomorrow in the hearing. Germany and Belgium have banned elective abortions after 14 weeks. Now, this law in Mississippi has set that at 15 weeks, but Germany and Belgium, 14 weeks. Denmark, Norway, France, a very live and let live country, if ever I've heard of it, draws the line at 12 weeks. 12 weeks. So when the Supreme Court hears this case tomorrow, they will have an opportunity to decide to place the United States of America in the broad mainstream of international thought on this. There are so many reasons why I'm happy today and encouraged today that we have this opportunity to make a case based on the facts. And Mr. President, I will say this. My heart and my thanks go out to the millions of Americans right this minute who are doing what some think is a quaint thing, performing an act that many people are skeptical about at this point. But I stand with those millions and millions of Americans who are right at this moment praying for the Supreme Court, praying for wisdom in these 9 appointed and confirmed figures. They're praying for the right words to be said by the attorneys, and they're praying for the future of our great country. This is our opportunity, and we have every reason to believe that we're on the right side of history. And I stand with the people who are bringing this case, and I stand with the people of Mississippi and the millions upon millions of Americans who are praying for the right decision. And I yield to my good friend from across the river, the junior senator from Louisiana, and I know that my friend from Mississippi is also waiting to speak.
Mr. President.
Senator from Louisiana.
Thank you, Mr. President. Mr. President, we talk a lot in this chamber, as well we should, about the least among us, about how we can protect and lift up the powerless. And that's a good thing. I can't think of any person who has less power than a potential human life, than an unborn baby. Now, Roe v. Wade is, of course, about abortion. We know that. But it's also about something else. Roe v. Wade is also about federalism. Roe v. Wade is also about the American people. Roe v. Wade is about whether a finite group of the managerial elite, and by the managerial elite, I mean the entrenched politicians, the bureaucracy, the media, the academics, the corporate phonies, all of whom think they're smarter and more virtuous than the American people, should have the right to make moral decisions for the American people instead of the American people making those decisions for themselves. That's really what Roe v. Wade is about. Now, Mr. President, I'm pro-life, and I am anti-Roe v. Wade. So I want to say up front, I do have an opinion. But, Mr. President, even pro-choice legal scholars who believe in legalized abortion on demand understand, as does every fair-minded person who knows a law book from a J. Crew catalog, that Roe v. Wade is one of the most arbitrary, it's one of the most ad hoc, it's one of the most poorly reasoned decisions in the history of the United States. In Roe v. Wade, as you know, Mr. President, the United States Supreme Court held that a generalized right to privacy, not explicit in the Constitution, means that a woman has the virtually unfettered discretion to terminate a human life. Some, to be fair, would say a potential human life, before viability. What's viability? As my colleagues talked about, that's a really, really good question. But I digress. Anyone, Mr. President, who knows a law book from a J. Crew catalog also knows that there's absolutely no foundation, not in the text, not in the structure, not in the history, not in the tradition of the Constitution for a constitutional right to abortion, and certainly not on the basis of some unmoored general right to privacy that's not enunciated in the Constitution. And don't even get me started, Mr. President, on Roe v. Wade's trimester analysis and the ruling. Try to find trimester in the United States Constitution. You won't. You can't. The truth is, and people on both sides of this issue who are fair-minded and reasonably objective, and by that I mean can see the other point of view, the truth is that Roe v. Wade's constitutional right to an abortion is a 48-year-old judge-invented rule that represents the United States Supreme Court winging it. Now, I know what we were told. We were told back in the 1970s, look, we've got to have a national rule to settle this issue. Only Washington, D.C. can settle this issue. We have to have a rational rule. We need some peace in the land. We need consensus. How's that working out for us, Mr. President? Roe v. Wade didn't settle anything. Now, in the Dodd case, which the United States Supreme Court is about to hear, the United States Supreme Court has a really rare opportunity to say, as Justice Scalia wrote in one of his opinions, that value judgments made on behalf of people should be voted on by those people and not dictated from Washington, D.C. In the Dodd case, the United States Supreme Court, Mr. President, has the rare opportunity to say what we all know, and that is that America is this big, wide, open, diverse, sometimes messy, sometimes dysfunctional, sometimes imperfect, but always trying to get better group of good people. That's what America is. And we don't always agree, especially not on value judgments, especially not on the ultimate value judgment, like when it is appropriate to take a human life. That's why we get to vote. That's why we get to vote. And that's why we have elected representatives who oftentimes vote on our behalf. Elected representatives who also can be unelected if we don't like how they vote. And finally, Mr. President, in Dodd, the United States Supreme Court has the rare opportunity to defederalize and deconstitutionalize abortion and return the issue to the states where it was before Roe v. Wade. The United States Supreme Court in Dodd does not have the opportunity, and this is important, to say no right to an abortion in America. Let me say that again, because some of the proponents of Roe v. Wade, I think, have shaded the truth on this. At issue before the Supreme Court in Dodd is not the right to have an abortion. It's the right. The issue before the Supreme Court in Dodd is what's the appropriate political forum to make these value judgments. Is it the government or is it the people? And I hope, Mr. President, that the United States Supreme Court takes advantage of this rare opportunity before it. Mr. President, I yield to the senator from Mississippi.
Mr. President.
Senator from Mississippi.
I join my colleagues today highlighting the momentous occasion for not only my home state of Mississippi, but for our entire nation. Senator Roger Wicker and I could not be prouder of our state. Tomorrow, the United States Supreme Court will hear oral arguments in Dodds versus Jackson Women's Health Organization, a challenge to a Mississippi law banning most abortions after 15 weeks. This law, the Gestational Age Act, was introduced by my friend, Mississippi State Representative Becky Curry, and was signed into law by Mississippi Governor Phil Bryant in 2018. This case presents a once-in-a-generation opportunity for the court to reconsider decades of misguided abortion law that began with Roe v. Wade and has continued under Planned Parenthood v. Casey. There is no doubt that this case is the most significant pro-life legal opening in half a century, and certainly in my lifetime. I am very proud that my state of Mississippi is in the center of this. In the 48 years since the decision in Roe v. Wade, 62 million unborn babies have lost their lives. This is a terrible moral stain on our nation that we have a chance to reverse at long last. There are many reasons for the Supreme Court to reconsider its course. For one, medical technology has made significant advances, especially with ultrasound technology, making clear what those of us in the pro-life movement already knew, that unborn children are human beings. Thanks in large part to the ultrasound technology, we now know that by 15 weeks, an unborn baby has a fully developed heart with a strong heartbeat, responds to touch, and can make facial expressions, yawn, hiccup, and suck their thumbs. For another, the United States is a real outliner in the world when it comes to the abortion issue. We are one of only 7 countries that allow abortions on demand up until the moment of birth, along with the likes of China and North Korea. The Supreme Court should uphold Mississippi's law, bringing our nation closer to the international consensus on human rights for the unborn. As a legislator, I am confident in saying it is time for our laws to reflect what the rest of the world has already figured out, that life exists before birth and it needs to be protected. The only difference in a fetus and a first grader is 6 years. Since the Supreme Court announced it would take up the Dobbs case, I have been earnestly praying for this case. I've prayed for the members of the Supreme Court to be open to the legal and moral arguments against Roe v. Wade. May God grant them the wisdom for the task and grace for the unborn. I've also been praying for my friend, Mississippi Attorney General Lynn Fitch, our State Solicitor General Scott Stewart, and the many others in the AG's office who have worked tirelessly to represent our state so well in this case. With the oral argument scheduled for tomorrow morning, I pray that God would grant them all confidence and courage, as well as the right words to say in the court. Most of all, I've been praying for all the unborn children whose right to life hangs in the balance of this case. Throughout this time, I've kept the words of 1 Samuel 1:27 close to my heart. For this child I have prayed, and the Lord hath given me my petition which I ask of him. So today, tonight, and tomorrow morning, I will be praying without ceasing. I hope each of you will join me in prayer of this historic court decision that started in Mississippi. May the Dobbs case restore the sanctity of life and reverse the moral stain of Roe v. Wade. Thank you, Mr. President.
Mr. President.
Senator from Kansas.
For nearly 50 years, Roe v. Wade has been a disaster for our country and its citizens. 60 million unborn lives have been lost to abortion, and our politics have been distorted by a ruling that deprives the American citizen, the voter, of the right to determine questions of which there is constitutional ambiguity. The Senate confirms individuals to the judicial branch to be judges. They are to judge, not to legislate. Listening to those whom we represent and proposing legislation on their behalf is our job here in the Capitol and the job of our representatives in state legislatures throughout all 50 states. The separation of these powers is crucial to how our democracy functions. Yet, previously iterations of the Supreme Court have seen fit to usurp this legislative power, particularly as it relates to abortion. In doing so, a majority of these unelected judges and justices have relied upon specious jurisprudence to eviscerate state laws that protect the unborn. You don't need to take the word of a conservative Republican from Kansas. Writing when she was a circuit court judge, the late Ruth Bader Ginsburg explained, quote, Roe v. Wade invited no dialogue with legislators. Instead, it seemed entirely to remove the ball from the legislator's court. One more liberal law professor acknowledged that, quote, Roe short-circuited the democratic deliberation that is the most reliable method of deciding questions of competing values. These assessments are exactly right. The fallout of Roe, as affirmed by Planned Parenthood versus Casey in 1992, is obvious. A vacancy to the Supreme Court has become a cage match, a fight here in the United States Senate. Someone as eminently qualified as Amy Coney Barrett should have been confirmed unanimously. Today, many of my Democrat colleagues support packing the Supreme Court with more justices because they believe the court will block their agenda, which is ironic because for nearly a half of a century, virtually every state effort to provide protection to unborn babies has been foiled by the judicial branch. Something terribly wrong has happened to our democracy when so much energy is focused on the court. Again, quoting then Judge Ginsburg on Roe's attempt to put the issue of abortion to bed, she said in 1985 the court's, quote, heavy-handed judicial intervention was difficult to justify and appears to have provoked, not resolved, conflict. And in 1993 declared that the ruling, quote, prolonged divisiveness and deferred stable settlement of the issue. Given these examples of our polluted discourse, no one can reasonably say that the politics of abortion have improved since then, and in fact, it has only gotten much worse. What has improved, however, is our understanding of the science of embryology. Regrettably, it is not enough to say a unique human life begins at the moment of conception for it to receive protection. But we know when unborn babies feel pain, we know when they can survive outside the womb, and a remarkable 4D ultrasound reveals what we already knew. These unborn babies are fully human and deserve the right to life, and yet our legal regime denies them that right. Because of Roe, a child in America can be terminated for any reason, up to the moment of its birth. That places us in the United States in the company of China and North Korea. Surely a democracy founded on the belief that all people are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, has a greater respect for human life than these brutal communist regimes. Tomorrow's Mississippi case will test that proposition. However, there is no doubt that the reversal of Roe will not end the practice of legal abortion. Several states have already enacted permissive abortion laws that would remain even on Roe's demise. The point here is that my effort and the effort of my colleagues and millions of other Americans to defend life will continue, regardless of how the Supreme Court rules in the coming months, including in my state of Kansas. These efforts will depend on civil persuasion of our neighbors and responsive state and federal legislators. We'll need legislation that protects the unborn and assists new families in caring for their child. Tomorrow, the Supreme Court will hear the most significant abortion case in the last 30 years, Dobbs versus Jackson's Women's Health Organization. This case provides the court the opportunity to relinquish the legislative power it has assumed and return it to the people and their representatives. The court will be better for it, and so will our politics. And most importantly of all, millions of future voices will get to have their say in the process too. I now yield the floor to my colleague, the Senator from Nebraska, Senator Fischer.
Mr. President.
Senator from Nebraska.
Mr. President, Dobbs versus Jackson Women's Health Organization, the case that will come before our nation's highest court on December 1st, is truly a historic case. It's about a law the state of Mississippi passed in 2018 to ban almost all abortions after 15 weeks of pregnancy. When I was a member of the state legislature in Nebraska in 2010, we passed the Pain-Capable Unborn Child Protection Act. Nebraska's bill banned most abortions after 20 weeks, the point when science at that time told us that unborn babies start to be able to feel pain. We were the first state in the country to pass a law of this kind, and in our Nebraska unicameral, we passed it with 44 yes votes and just 5 no votes. Nebraska has a unicameral, one House 49 senators. We had pro-choice, pro-life, Republicans, and Democrats that voted for this bill. We had a pro-choice Republican. We had a number of pro-life Democrats. In fact, we had a former Democratic National Committeeman vote for this bill. All we cared about was protecting the most vulnerable people in our society, unborn children. I was proud to support Nebraska's bill. I was proud that pro-life Democrats, pro-choice Republicans put their differences aside to vote for it. And I'm proud today to stand with Mississippi as their law comes before the United States Supreme Court. Back in July, I joined more than 200 of my colleagues in the Senate and the House of Representatives in filing an amicus brief supporting Mississippi's bill. In our brief, we argued that the precedents the Supreme Court set in Roe v. Wade and a later case, Planned Parenthood v. Casey, are outdated. When Roe was decided nearly 50 years ago, babies born before 28 weeks, they were not expected to survive. Today, the miracles of modern medicine have allowed babies born much earlier to not only survive, but to go on to live full and happy lives. Just last year, a little boy was born right next door to Mississippi in Alabama at 21 weeks. He was 132 days premature, and he weighed just 14.8 ounces. 50 years ago, it would have been unthinkable for him to live beyond a few days. But this July, he celebrated his first birthday. 50 years ago, ultrasounds and sonograms were not widely available. Today, they are an essential part of prenatal care. The pictures that these technologies enable families to see of their unborn children, even at the early stages of pregnancy, are often nearly identical to the newborns they will soon become. The advancements of the last 50 years have left no doubt about the humanity of the unborn. And as science continues to progress over the next 50 years, new developments are going to keep allowing babies born earlier and earlier to survive and to thrive. The laws of just about every developed country have kept up with this rapid progress. But here in the United States, our laws are stuck in the past. The U.S. is one of only 4 nations on earth where certain states allow abortions up to the day of birth. That puts us in the uncomfortable company of China, North Korea, Vietnam. 90% of countries around the world limit abortion at 15 weeks, the same point as Mississippi's law, and some even earlier. In Europe alone, there are 8 countries with laws that are stricter than Mississippi's. That includes Germany, where abortion is illegal in most cases just after 12 weeks. Women seeking abortions before 12 weeks in Germany also have to go through a 3-day waiting period and a mandatory counseling session. Mississippi's law isn't that different from Germany's. In some ways, it's even more lenient, but it's still being challenged in our court system based on legal decisions from decades ago. Our laws are outdated, and America's unborn children are paying the price. Since 1973, more than 60 million abortions have taken the lives of more than 60 million American children, many of whom could have survived outside the womb. It is past time for the United States to move into the 21st century. The Supreme Court has a chance to help us do that by upholding Mississippi's Senator Marshall, who is also a doctor, gynecologist, and obstetrician.
Mr. President,
Senator from Kansas.
I want to start by thanking the senator from Nebraska for helping bring light to the significance of the Dobbs Supreme Court case. For some 30 years, I had the honor, the privilege of delivering a baby most every day of my life. Some 5,000 babies in residency, another 5,000 babies in private practice. Some days I delivered none, other days it was one or two. There were days when I delivered 10, 11, 12 babies a day. Some of those babies I could fit in the palm of my hand. Other babies, I delivered several babies over 15 pounds. It's now been almost 4 years since I delivered my last baby, but I'm still often asked, do I miss obstetrics? And let me tell you, boy, do I miss it. My favorite part of the whole process, as I recall, though, was after a hard, long labor, is seeing that baby emerge from the mother, holding that baby in my hands and waiting for it to cry. Sometimes it was crying as it entered into this world. Other times it took 5 seconds, sometimes 30 seconds, sometimes a minute or two would go by as we worked on the baby. But my favorite part of every pregnancy was taking that crying baby and handing it over to a new mom and dad. It was absolutely the most spiritual moment of my life, the closest I ever got to seeing what God was truly like, to see a newborn baby in the hands of its mom and dad with this just total agape love, this unconditional love. It was just the honor of my life to experience that almost on a daily basis. But today I want to talk about my favorite OB visit, which came at 15 weeks typically. At about 15 weeks after conception, moms would come in for maybe their third or fourth visit. My first question was always, are you feeling the baby move? And the mom's eyes would light up, and maybe she had had a miscarriage before, maybe she was an infertile couple, or maybe this was her third or fourth baby, but everyone, when I asked him, are you feeling the baby move yet? Her eyes would light up. And mom would lay down on the bed, and I would put my hands on her abdomen and feel the size of her uterus to assess how big the baby was. And so often as I put my hands on her skin, I could feel the baby pushing back or kicking back. And then we'd put the Doppler on the mom's abdomen and listen to the baby's heartbeat. And usually if there was a brother or a sister in the room, that baby's big brother or big sister would squeal, "Mommy, what's that noise? What's that noise?" And almost every time as I heard the sibling ask mom that question, you could hear the baby's heart rate increase with excitement. That baby inside the womb knew that was its brother or sister there that was talking, and it was excited to hear that voice. And the mom would respond, "Darling, that's your little baby brother or sister." And as mom spoke, the baby's heart rate would slow back down to what it was before, that calming voice. So that brings me to the Dobbs case. The Mississippi Dobbs case protects life after that 15-week visit I just described. I recognize and believe that life begins at conception, but maybe not all of America agrees with me on that. But I do believe with all my heart, a huge part of America agrees, we should not allow abortions on babies that can feel pain or that could respond to their mom's voice or their siblings' voices, right? Ask yourself that same question. An unborn baby that can feel pain, that knows its mom's voice, should that baby be deprived of life outside the womb? I struggle as I watch America being one of 7 nations that allows abortions after 15 weeks. And I point out that all these other nations are agnostic or totalitarian nations for the most part. And I struggle as I recall the moms and dads who lost a baby at 15 weeks or at 18 weeks or at 23 weeks. I recall their mourning. I recall their tears. I recall that how in our hospital we might be struggling to preserve a pregnancy, to save a baby's life, to be resuscitating a baby, while in a nearby town, the abortion industry is claiming another life at this same gestational age. I struggle to think we live in a society that allows this barbaric treatment of the unborn. We hope and pray that this landmark Supreme Court case will result in a decision that reflects the values of most Americans and protect life after 15 weeks. Unfortunately, because of a 2019 Kansas Supreme Court case, my home state of Kansas has become an abortion destination. An abortion destination. The Kansas Supreme Court has paved the way for unlimited abortions, abortions paid for with tax dollars. And that's why back home I'll be fighting for the Value Them Both Amendment, which protects and values both the mom and the baby. Look, America does not want unlimited, unregulated abortion industry. This is not consistent with our values. I believe most Americans value them both. We value both the mom and the baby. I fought my whole life for moms and babies, and I'm going to keep fighting for them both. Mr. President, I'd like to yield the floor then to my friend and mentor from Texas who's been leading the fight up here in D.C. for years, and look forward to him sharing with us what Texans are talking about the significance of this Dobbs Supreme Court case. Thank you.
Senator from Texas.
President. Mr. President, I want to start by thanking my colleagues for being willing to stand up and defend innocent human life. I remember recently watching a young woman walk across one of the downtown bridges in Austin, Texas, carrying a sign. It said, "Abortion, anytime, any reason." That's what she was advocating for. I was shocked when I saw it because I thought even the most ardent advocates of abortion would not take that position, denying the humanity of this unborn child. But apparently that's what has become here 48 years after the Supreme Court first created a right to abortion out of whole cloth as a constitutional right. You look in vain in the Constitution of the United States, as well as the amendments to the Constitution, for any reference at all to abortion. What you will find, if you read the Declaration of Independence, is a familiar statement to all of us. July the 4th, 1776, the 13 states then that made up America said, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness." By the way, there's no asterisk, there's no footnote that said if you are an unborn human life, that you are denied this unalienable right to life. Such noteworthy figures as Ruth Bader Ginsburg, who was probably one of the most aggressive advocates for abortion rights in the United States Supreme Court, later in life decried the fact that by the Supreme Court holding a right to abortion as a constitutional right denied the very sort of give and take and debate by which our differences are resolved in the states and at the national level. And I'd just like to point out some of the misinformation that you hear and read about Roe versus Wade. If Roe versus Wade is no longer the precedent by which abortion rights are decided, it will not mean that abortion will not be available in many, if not all, of the states. What it will mean is that it will be decided under our federal system on a state-by-state basis, according to the decisions made by elected state leadership, including the legislature. (1948) was when Richard Nixon was inaugurated for the second time as President of the United States. Suffice it to say that a lot has happened since then, a lot. And I think it's entirely appropriate that the United States Supreme Court revisit its precedents, including Roe versus Wade, decided in 1973, and decide if that precedent has stood the test of time. By the way, serving on the Judiciary Committee, we frequently have nominees for the Supreme Court of the United States come before the committee, and many of my pro-choice colleagues will say, "Do you agree, Judge or future Judge, that Roe versus Wade is the precedent of the United States Supreme Court?" And of course that is, along with Casey and the other decisions that have been decided since then. But they act as if the United States Supreme Court cannot revisit bad decisions and correct those bad decisions. To act as though Supreme Court precedent is somehow sacrosanct would still leave us with the likes of Dred Scott, which treated African Americans as less than fully human. Obviously, we fought a civil war. 600,000 Americans died. That'd be the equivalent of 3 million people today in a bloody civil war that tore our country apart. So being able to revisit those precedents, especially in light of the passage of time and over long experience, is entirely within the purview and entirely appropriate for the Supreme Court to do. Well, we've heard from my other colleagues that since Roe was decided in 1973, more than 60 million abortions have been performed in the United States. As originally was decided, Justice Blackmun wrote an opinion and established an event he called viability. Abortion was basically, the argument is by the opponents of, or the proponents of Roe, that somehow this decision by Justice Blackmun saying that abortion should be widely available pre-viability, that we should not be able to reconsider or take a look at that. The truth is, Judge Blackmun admitted this was an arbitrary standard. What does viability mean? We've heard 7 countries around the world have more permissive or equally permissive abortion laws as the United States. I frankly don't want to be in the same company as North Korea or the People's Republic of China, governed by the Communist Party. I would hope that America would aspire to something different and better and more humane, more in line with our fundamental statement about the unalienable right to life. But the fact that America's only one of 7 countries that allows elective abortions after 20 weeks, which, as I said, puts us in the same category as Communist China and North Korea, you would think that would raise a huge red flag and say something is terribly wrong here. how is it that we are in the same category as communist North Korea, communist China, when it comes to the value we place on unborn life? Well, unfortunately, we've seen the right to life become a partisan issue in the United States Congress. When you take a look at the pro-life legislation which has been introduced over the last years, we saw last year, for example, our Democratic colleagues filibustered legislation to outlaw elective abortions after 20 weeks, which is when science tells us that an infant can feel pain. Then they blocked a bill requiring physicians to provide life-saving care to infants who survive abortions. This is care that any other newborn baby would receive. And yet our colleagues, so concerned about the backlash among their pro-abortion constituents, blocked it, denying a child born alive after a botched abortion the same sort of care that any other newborn would be entitled to, and they blocked it. And the latest attack on unborn babies' right to life is Women's Health Protection Act. This bill would undermine state laws limiting abortion even after viability and undercut the Supreme Court's ruling that defined our current definition of viability. And what does viability mean? Even at 20 weeks, can an unborn child live without medical attention and support from their mother or medical personnel? Of course not. This is an arbitrary line drawn by the Supreme Court in 1973. And as we've heard from many of my colleagues, medicine has thankfully advanced considerably since that time. Well, even though the United States Congress seems to be stuck when it comes to the issue of abortion and respecting the right to life of unborn babies, thankfully the states have taken the issue up, which is why states like Mississippi have passed their own legislation to protect unborn babies. Pro-abortion advocates say, well, 15 weeks, which is what the Mississippi law says, that a right to abortion only for the first 15 weeks of a pregnancy, that violates constitutional rights. But it's interesting, it's no less arbitrary than this notion of viability, which suggests that a child can live, which they cannot, outside the mother's womb, even if they're 20 weeks or 24 weeks of gestational age. Interestingly, a number of states, like Massachusetts and Nevada, abortions are restricted after 24 weeks. In California, Washington, Illinois, those are among states that explicitly restrict abortions after viability. The American people clearly stand behind protection of unborn life. This summer, a poll found that 65% of Americans believe that abortion should be illegal in the second trimester. That's the second 3-month period of a 9-month pregnancy. Opposition to third trimester abortion is even stronger. 80% of Americans are opposed to a third trimester abortion. And indeed, the Supreme Court of the United States upheld a Nebraska law banning late-term abortion, which is essentially producing a delivery while the child is still alive, killing the fetus, and then completing that abortion. The Supreme Court of the United States upheld a ban on that third trimester late-term abortion, that brutal and barbaric practice that even the Supreme Court could not abide. Last June, a baby born at 21 weeks and 2 days. This last summer, that baby celebrated its first birthday. That's what's at stake here when you're dealing with more than just one person, or you are dealing with more than just one person. The question is, How do you balance and deal with the rights not only of the woman seeking the abortion, but also the unborn child? Right now, under its current jurisprudence, that unborn child is not even considered a human. America cannot be its best if we devalue lives of the most vulnerable among us. I believe that babies with heartbeats, fingerprints, and taste buds deserve some protection under the law. I'm proud of the efforts led by our colleague, Senator Lankford, and others to make sure that we actually have a discussion about this issue and don't just sweep it under the rug. And we don't just let the pro-abortion lobby mischaracterize what we're talking about, as if eliminating Roe would eliminate abortions in America. It would just allow the states to do it on a state-by-state basis. But actually, Roe was a made-up right, created a constitutional right that's not even stated in the Constitution itself, and it created an arbitrary time limit in which abortions could be performed or not as a matter of constitutional rights. So I join the rest of this body in this country in awaiting the Supreme Court's ruling. I believe that it's more than appropriate for the Supreme Court to revisit its precedents that essentially disparaged and denigrated the right to life of an unborn child. Mr. President, I would yield the floor to my friend from Oklahoma.
From Oklahoma.
In December of 1952, and again in December of 1953, the Supreme Court was packed. There was lines out into the hallway with people waiting to get in to hear oral arguments. In December, the court would hear arguments on the legality of segregation brought by Thurgood Marshall, representing the Brown family from Topeka, Kansas. Just 56 years before Brown versus Board of Education, segregation was protected by the Supreme Court in Plessy versus Ferguson. They ruled that separate but equal facilities were constitutional, thus enshrining the national disgrace of segregation into America. An absolutely terrible decision by the Supreme Court that haunted our nation for decades. And it took 56 years before the Supreme Court corrected its wrong. Now, more than a century past the Plessy versus Ferguson decision, the nation still celebrates the court that decided the Brown versus Board of Education case as justices righted a great wrong against millions of people. There was a simple lesson in that decision. When the court made a mistake, it should fix its mistake. In a lesser-known case that affects just about every American now, in 2018, the Supreme Court overturned by a 5-4 decision 51 years of precedent on the collection of taxes for businesses called the Physical Presence Rule. Many people now know it as the Internet Tax Rule. It changed the way taxes were collected on the Internet. When they made that decision in 2018, there was great confusion and consternation. Statements that it'd be impossible to implement and it would bring certain destruction to Internet commerce. In fact, in the dissent in that 5-4 decision, the minority in the court stated this: e-commerce has grown into a significant and vibrant part of our national economy against the backdrop of these established rules, including the Physical Presence Rule. Any alteration of those rules have the potential to disrupt the development of such a critical segment of our economy. It should be undertaken only by Congress. The court should not act on this important question of current economic policy solely to correct a mistake it made over 50 years ago. It was hand-wringing by the court, the minority there, that they opposed correcting the obvious mistake of the court from 51 years before because it could hurt the cyber economy. In other words, doing the right thing involved a risk. Well, yesterday was Cyber Monday. It was one of the largest single days of purchasing online in history. The court did the right thing, and the economy kept going. There was a simple lesson in that decision. When the court made a mistake, it should fix its mistake, even if it was 50 years later. Tomorrow, the Supreme Court of the United States will hear oral arguments in what could potentially be the most consequential case for human rights in 48 years. Tomorrow, at 10 a.m., 9 justices will hear arguments and ask questions of the Attorney General of the state of Mississippi and counsel representing an abortion clinic in Mississippi. Tomorrow morning, the court will consider whether all pre-viability prohibitions on elective abortions are constitutional. Tomorrow, this court has the opportunity to uphold a self-evident truth to personhood, the facts of science and of our heart's declaration, the right to life, liberty, and the pursuit of happiness. Simply stated, the court has an opportunity to correct its mistake from 1973, 48 years ago. In 2018, the Mississippi legislature enacted the Gestational Age Act, which limits abortion to 15 weeks of gestation, except in a medical emergency in cases of severe fetal abnormality. Jackson Women's Health Organization, an abortion clinic in Mississippi, sued. Federal courts held that the law was in violation of the court precedent in Planned Parenthood versus Casey. Now it is known as the Dobbs case. It stands before the Supreme Court at 10 a.m. tomorrow. This case presents an opportunity for the court to reconsider Roe v. Wade and turn the role of legislating on the issue of life back to the states where it was pre-Roe v. Wade. Roe v. Wade, as this body knows extremely well, the Supreme Court decided the Constitution guarantees the right to have an abortion until the viability of a child, with very little understanding of the term viability. Years later, in Planned Parenthood versus Casey, the court also said that the government couldn't place an undue burden on access to abortion, which has been used to block many laws that aim to protect women and children. Both decisions were completely arbitrary and not based in constitutional law. Viability, quite frankly, is impossible to define because children develop at different speeds. One child, like Curtis Means, who just left the University of Alabama at Birmingham Regional Neonatal Intensive Care Unit after he was prematurely delivered at 21 weeks, 1 day, the youngest child to be born ever. Another child, though, may not survive if they were even delivered at 32 weeks. Viability was completely invented by the court in 1973 as a standard and is impossible to actually track. America's not forgotten about these children. We've not moved on, and we've not just accepted Roe v. Wade. Because when we see a child, as this one is, at 15 weeks, we actually see a baby, shockingly enough. 48 years ago, the Supreme Court may have decided that a woman had the right to an abortion, but we never lost track of humanity. Abortion's not just a medical procedure. It's the taking of a human life. I talked this morning with an abortion survivor, and yes, they do exist by the thousands. She's in her 40s. She has children of her own now. She survived a botched abortion and was actually delivered alive during an abortion procedure. She was taken by a nurse to the NICU unit of that hospital, and she is still alive and thriving today. I sat there with that abortion survivor, thinking that abortion is not about random tissue. It's about a person. Quite frankly, this morning, the person who was sitting right in front of me. Now, I understand full well I'm a pastor who's now a senator. I'm fully aware that I have a biblical worldview, and my dedication to children is not just because I'm a follower of Jesus and believe that every person is created in the image of God. I also firmly can look at the science. The science is clear to anyone who's willing to get past the talking points and actually look into the womb. At the moment of fertilization, a new and distinct human being comes into existence. It's not just a fertilized egg, it's a new human. This new cell, which is called a zygote, shows behavior that's unlike the behavior of any other cell around it that's in the woman's body. The DNA inside that cell is different than the DNA inside any other cell in the mom's body. That cell has everything that he or she needs to become a fully developed human being. everyone listening to me right now, everyone, was once a single-cell zygote, completely dependent on your mom for nutrition. That's why we encourage moms to eat good foods, take prenatal vitamins, stop smoking, and all those things, because we want to protect the development of her child. Why? Because we all recognize that that's a child, and what a mom does now will affect the future for that child. As a baby grows in his or her mother's womb, it continues to develop. At 15 weeks, as this baby is, and that is what the Mississippi law is all about, is a baby that looks just like that. At 15 weeks, a baby has heart, lungs, skin, eyes, a nervous system. By 15 weeks, or a little over 3 months of pregnancy, this preborn baby is moving around and responds to touch. All of her organs are formed, and she just needs more time for them to grow and develop. Her heart already has 4 chambers. It's already beaten millions of times and pumps more than 6 quarts of blood per day. She cannot breathe outside the womb, but she is breathing inside the womb. She has arms and legs. She has 10 fingers and 10 toes, and normally, by this point, already shows a preference for being right-handed or left-handed. She has eyes, a lips, a nose, fingernails, eyebrows, even taste buds, and she can feel pain. This decision has both ethical, moral, and medical implications. Look in the mirror for anyone in this room. You've got fingers and toes and a lips and a nose and fingernails and eyebrows and taste buds. You can feel your heart beating. The only difference between you right now and this child is time. That's it. But for some, it's easy to just close their eyes and ignore the self-evident fact, because it's easier to talk about court precedent or choice. Because if we looked at each child and recognized this child for who she is, it's hard to process that in the last 48 years, 62 million children have died by abortion in America. And for some, they can't allow themselves to acknowledge what is self-evident, because it'd be too painful to think about 62 million children. Can I tell you, 62 million children is the combined population of Vermont, Alaska, North Dakota, South Dakota, Delaware, Montana, Rhode Island, Maine, New Hampshire, Hawaii, West Virginia, Idaho, Nebraska, New Mexico, Kansas, Mississippi, Arkansas, Nevada, Iowa, Utah, Connecticut, Oregon, Kentucky, Louisiana, Alabama, and Oklahoma combined. Court decision that led to the death of 62 million children is a court precedent that needs to be discarded. Prior to 1973, each state had its own laws on abortion. That's what would happen again if the court overturns Roe v. Wade. We'll have a patchwork of laws about abortion, just like we do right now on homicide. In some states, like mine, if a pregnant mother and her child are killed, the perpetrator faces 2 charges of murder, one for the mom, one for the child. In other states, the perpetrator would only face 1 charge of murder because that state doesn't recognize that child's existence at all. I think that's absurd. But that's a law in one state, and it changes from state to state. People can speak to their own state legislators about changing that law in their state and about recognizing the value of every child, even the child in the womb. But until they do, that child's a non-entity in some states. That kind of difference in homicide laws is allowed by the Supreme Court already. This court should give that same right to every state for every preborn child, not just for some. The law being debated in the Supreme Court tomorrow reflects the will of the people of Mississippi, just as many pro-life laws in Oklahoma and in our legislature have reflected the will of the people of Oklahoma. The arbitrary, outdated viability standard established by the court makes it harder for states to protect women from physical risks that accompany late-term abortions. It makes it difficult to allow states to protect preborn babies in the second trimester that can experience pain. The viability standard prevents states from banning dismemberment abortion. The viability standard deters states from protecting children diagnosed with Down syndrome, developmental disabilities, and children being aborted simply because they're male or female. It also prevents states from protecting the lives of their own citizens at any stage of development. I don't understand how infants have become a partisan issue. I really don't. There are some issues, as I talk to my colleagues on the other side of the aisle, I can see their perspective and their point of view. I may not agree, but I can understand their point of view. But on this issue, I do not understand how some people see a baby sucking their thumb in the womb and they see them only as medical waste. I don't understand how some people can support an abortion in one moment, but when they talk to a woman that's had an abortion or had a miscarriage, they immediately respond with, "Oh, I'm so sorry." If a miscarriage is the loss of a child, then what's an abortion? I don't understand how the same person who fights to protect the right to abort children also brings a gift to a baby shower and celebrates a mom and a baby. How can one child be worth celebrating and the other child be medical waste? I just don't understand that compartmentalization. Frankly, I don't understand how some people that are pro-abortion justify protecting bald eagle eggs in federal law, but have no problem supporting the taking of human life in the womb. Children are not medical waste. Children are beautiful, innocent, and valuable. Some people that are pro-abortion call pro-life people horrible names, and they say they're trying to limit a woman's choice and her freedom, while they work to protect her right to have her own baby, literally have its arms and legs torn off in the womb, so the child would bleed to death in the womb, and then each body part would be suctioned out separately. I don't consider that freedom. I consider that cruel and inhumane. They say it's a woman's choice. But when does the child get to choose? Some people in our nation actually celebrate the death of children like it's some glorious empowerment of a woman that she's able to pick and choose which baby will live or die based on her decision. I don't think that's empowerment. I think that's barbaric. Mother Teresa stated, "It's a poverty to decide that a child must die so that you can live as you wish." Change begins tomorrow. Tomorrow, the court will have the opportunity to uphold our Constitution, eradicate the outdated, oppressive, and deadly precedent, and turn our discussion about life over to the legislators of each state. Now is the time for this court to overturn Roe v. Wade. Our nation prides itself on human rights and individual liberties, but we have this huge, glaring exception. We deny the obvious fact of a child until they're born. We ignore a child's existence until it's convenient. I really believe in the decades ahead, our nation will catch up, and we'll look back on these years with grief. We'll be shocked that when we saw a pregnancy test that said positive, somehow we didn't figure out that meant positive for tissue. It meant positive for a baby. I look forward to the day when the United States will be a beacon of justice for every child, not just a few. When we'll be a nation that protects the weak, not just a nation that stands up for the strong. When we'll lead the world to protect the innocent and speak for those who cannot speak for themselves. When America is a beacon of hope for every child. Southern slave owners in 1830 denied humanity to their slaves. Men in 1900 denied women a right to vote. The United States rounded up Japanese Americans in World War II and put them into camps. All three of those were considered legal and appropriate at the time. All three of those were fought tenaciously when they were changed. And all three of them are a national embarrassment now. There was a time when the court ruled separate but equal was justice. Then 6 decades later, they reversed course, ending segregation. Justice requires, when the court gets it wrong, they correct their own mistake. This time, there are millions of children counting on the court getting it right. Blessed are those who have regard for the weak. The Lord delivers them in times of trouble. Psalm 41, verse 1. I yield the floor.